Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
All right, we are here with Robert Glassman today, and man, I have to say that, but for the pandemic, Rob and I may not even know each other to be friends. So those were some good times back in that pandemic, although they were hard to appreciate while we were going through them.
In retrospect, I think it was a silver lining for a lot of people. But it's good. It's good to be here, Dan. You've been so instrumental to my ascend to partnership at the firm and learning all the skills that make me who I am today. I owe everything to you, Dan. Everything.
Well, I appreciate that, Rob, but I think your mom gets some credit for birthing you. But beyond that,
My
I think it's
mom, my
appropriate.
dad, Brian Panish, Rahul Ravapudi, in that order.
And Dan Ambrose.
Ambrose, yeah.
Hey, top five. That's what I strive for. Is top
Your
five.
top five.
All right, Rob. All right, Mr. Glassman. I just call you Glassman from now on because Panish is like, I don't call anybody by their first name.
Sure.
I'm like, perfect. All right, so tell us, you just turned 40 years old recently, and finally you got the monkey off your back. You finally got your first 8-figure verdict that we're going to talk about, because I can imagine what it must like to be at PSR, to be a partner there. I mean, I'm sure they started second guessing it when the years kept creeping by and no big verdicts from Glassman, but you finally did it. So, just what was that case about? How did you, I mean, I know Panish set you up for it because they're like, we got to give Glassman the laydown. So what was that case about?
Well, it actually wasn't a layup, but
it was a joke. It was a joke. It was a little humor. We know it was a tough case in a conservative venue.
This is what it was. So we represented a guy in his early 40s who was on a motorcycle leaving work at UPS one early morning back in September 2019. He leaves work on his motorcycle and he's heading home when a large Los Angeles Department of Water and Power work van pulls out from a side street in front of him to make a left turn. Our guy couldn't stop in time and crashed into the driver's side of the van. Police report put the van at fault. There was a video of the crash. To me, I thought that it was clear cut. It was certainly the van driver's fault. But DWP disputed liability tooth and nail the entire time. When we designated experts, both recons took the video and analyzed it specifically for our guy's speed. Turns out our guy's going 60 miles per hour in a 35 mile per hour zone. So speeding tremendously on a motorcycle, and to make matters worse, for trial, we get sent out to Van Nuys. So I've got a conservative jury pool. I've got a guy on a motorcycle going 60 in a 35, and he did suffer some real injuries. He had a broken wrist. He had a broken pelvis. He injured his back. There were 4 surgeries in the case. Spent about a week and a half in the hospital. So the damages were real, but they disputed liability.
Okay, Glassman, that's enough of a setup, though, because before we get to the details of that, there's a few things we have to talk about. And first of all, how did little Robert Glassman, who has a picture of himself at 7 years old with his little coat and tie on the little calculator, how did little Robert Glassman one day decide, you know what?
Well, so born and raised in St. Louis, came from a very kind of conservative background, conservative place. I had no lawyers in my family. Didn't really know any trial lawyers, had no close family friends that were lawyers, but it was something that was just within. I did mock trial in high school. I loved it. I thought I was pretty good at it. It was exciting. I liked the competitive nature of it. I was always involved in student government, so I was always up talking in front of people, in front of crowds of, people at the school, and I always enjoyed that. So I thought, well, I like talking in front of people. I like mock trial. And I just think that this is something that I could be good at. And so I from high school, I knew I wanted to go to law school. I mean, I knew I wanted to go to law school before I even went to college. And uh, the only thing that kind of deviated from where I was then from where I am now is that I wanted to be an entertainment lawyer. I wanted to be an entertainment trial lawyer. So that's why I came out to LA. I didn't have any connections to Los Angeles. I didn't have family here. I didn't have friends. I had no connections whatsoever. But I came to Southwestern because it had this reputation of being a good entertainment program. And my friends, like my best friends from back home, were all coming out here too. We were like entourage. We were coming out to pursue entertainment. I was the only guy going to law school, but like I had a guy starting the mailroom at William Morris. My other buddy went to USC Film School. So we all came out to pursue it. I was the only one who left. My other friends are crushing it now in the entertainment business, but I didn't like it. I took copyright, hated it, wasn't passionate about it, bored out of my mind. I worked at an entertainment law firm my first summer out of law school in Beverly Hills, hated it, not passionate about it, bored out of my mind. So I pivoted and I started working at the DA's office. Fell in love with it. Loved it. You're in court all the time, the camaraderie with the other law clerks and the DAs. I loved it. And I thought,
But hold on a second, though. You just told me you liked competition, right?
that's right. I know what you're gonna say, how do
Right.
you
Like, give everybody a break here, okay? Anybody that likes competition and becomes a prosecutor is soft, okay? You're insecure. You need to be, you need to have every advantage of the world. You need cops that will lie for you, and adjust the evidence. So and judges that put their thumb on the scale.
well, I don't know about that.
And
I don't know about that, but they do have 97 to 99% conviction rates for a reason. I mean, look,
no, because there's a lot of cheaters in the government, and anybody that's ever been a criminal defense lawyer knows it. Like 1 out of every 100 cops might be honest. So let's get past this though, and just don't talk like this was some competitive environment at the
well,
DA's office.
I want to say though, there are some good, honest DAs out there. My
Like your
wife is
wife.
one of them. She's
Okay,
we met.
we're gonna give you the benefit of the doubt on that one, Glassman.
She was a progressive DA before it was popular to be a progressive DA.
And now it's unpopular.
Now it's not popular
Again,
because they went too far.
I know we got to have
Right.
balance, man. I mean,
Yeah.
your wife needs to run to be the elected DA, so she can have the proper balance of compassion yet the firm
It would be
hand.
great for
So that society is orderly.
right. Right. Yeah, totally. No, I mean,
It's down the road.
make good deals when good deals need to be made and dismiss cases when you don't have the evidence. The end.
See, they never did that where I came from. They didn't have the evidence. I would show them they'd have the evidence. They'd say, well, I guess it's going to be easier trial for you, isn't it, Dan? I'm like, how can you put somebody through this? You heartless, so many terrible human beings. But the great part is when I see them on Facebook 30 years later, they're still at the prosecutor's office. That's God's wrath for them.
That was back in Michigan, right? I mean,
That was back in Michigan, no doubt about it.
yeah, it's a little bit more red there. A little bit more red than here.
Yeah, but we're getting better.
Hmm.
We're getting better. I think it's going to be. I think we're going to hold the blue wall this year. But back to trial work. So you so you get out of law school. You got this dream of having power and being the man. So you want to go to the DA's office, but you're there at the DA's office, and from my understanding, that at least something positive came in because you met your lovely wife, right?
That at least came from it, but it was
That came
2009. 2009, LA County was on a hiring freeze. So before I took the leap from law school there, I didn't want to do that because I wanted to have a paying job. I just spent 3 years in law school. I wanted to have a real job. I didn't want to go work for free at the DA's office, which is what I would have to do if I went. So I was taking this mass tort litigation class, great professor at Southwestern. He was like, why don't you pursue being a plaintiff's lawyer? I could see you being a plaintiff's lawyer. He was a defense lawyer at a big firm back on the East Coast defending big mass tort cases when he was practicing. And he always told me that I reminded him of some of the plaintiff lawyers that he went up against. I didn't know anything about plaintiff's law. I didn't, it wasn't like what it is today. In law school at Southwestern, Loyola, UCLA, Pepperdine, USC, it's all about being a plaintiff's lawyer and all about, Cala and big names come on campus and you hear these great stories, these war stories, but these epic trials from Brian and others. And it motivates you to want to do that. I didn't have that when I was in law school. Like it wasn't so in vogue when I was there. Everyone wanted to be a DA or a PD when I was in law school. If you had the grades, you went to big law. But like being a plaintiff's lawyer wasn't the thing that everyone wanted to do like it is today. Everyone wants to do it now.
Really?
I feel like, look, I'm very involved with my law school. I'm back there a lot. There are so many students now who all they want to do is do what we do. And that's good. That's a credit to, to the leaders of our bar and to on the defense side who are making these students know that there's this great career ahead of them as either, a plaintiff's trial lawyer or a defense trial lawyer. It's good.
Oh, come on. A great career as a defense
But
trial
look,
lawyer, billing hours every day, being in the thumb of a major corporation. Come on, what could be fun? Every person that does that talks about purgatory and hell
well,
for years of grinding their lives away until they finally have purpose and join the
a
plaintiff's
lot of
bar.
it's bad. A lot of it's bad, and a lot of people do make the transition over to our side. But there are still some good, really good, decent people on the other side.
But it's so
It's
rare.
rare. It's rare, but when you get
It's
them,
rare.
it's refreshing, and they're
Oh,
actually more dangerous than the assholes.
oh yeah.
I mean,
It's like,
wait, it's so
the criminal. It was like when I was a criminal defense lawyer, it's like, coming across an honest cop. It was like the guy that just did his job, that just tried to find the evidence and didn't care one way or the other whether the person was convicted because that wasn't his job.
right.
It was refreshing, rare, and scary, like you said, because I'm like,
Totally,
wow,
totally. So we need more
even I
people
believe
like
this guy.
that. So
He's likable.
if we can encourage more, moral, ethical, good, good trial presentation people to go become defense lawyers, that's actually good for everyone, I think. But anyway, so back to the story, I wasn't going to be a DA. So this guy, professor, was like, go look at being a plaintiff's lawyer. And I was like, okay. So I researched 3 firms. It was Panish, and Boyle. This is 2009. Panish, and Boyle, 7 lawyers at the firm. I didn't know who Brian Panish was. Girardi and Keese, and
You dodged a bullet there.
Bullet, and Green, Burlett and Wheeler. Great firm in Santa Monica. So I applied.
Bruce Boylett, nicest guy in the whole world.
Right.
Like,
Totally.
what a G.
Totally. At the time, those 3 were like upper echelon. I focused my efforts on getting into one of those 3 places. Somehow got my foot in the door at PSB, interviewed with Kevin Boyle, who was like, U.S. Supreme Court clerk for Justice Rehnquist, super smart guy, worked at Kirkland. He looked at my transcript. I had a lot of C's. And I remember he asked me, what's up with all these C's? And I gave some bullshit response like, well, I was really focused on, networking, and I was student body president. I was, top of the trial ad teams. I was just focused on other things, but I leveled out, once I got the hang of things, because I went straight from undergrad to law school. I was very much in that college mindset when I started law school. I thought I could just wing it. I don't think you can really just wing it in law school. You got to really roll up your sleeves and put in the work. I didn't know that, because in college you can kind of fly by it. You can wing it. So it took me a while to adjust to law school. I got better grades towards the end. But anyway, that interview with Kevin was like awful. Just went really bad. But I think they just had a need for a young grunt lawyer to just get
Desperation.
shit done. So he invited me back to interview with Panish for round 2. That interview went just as bad as the first one. I did not think that I won him over by any stretch of the imagination. He asked me if I had ever had a job before, and I said, well, I'm working at the DA's office. He was like, oh, that's not a real job. Like, so you've never had a job before? Like, that's
You've never had a job in your whole life, Glassman?
No, I did, but I was like working in hospitality. I worked as like a busboy at a restaurant. I was like.
That's good training for you.
Cabana boy at the Peninsula. I was a concierge at the Ritz. I worked at a movie theater, like stuff like that. I didn't have like an office job.
But but the reality is those jobs are very helpful for being a
those
plaintiff's
jobs,
lawyer.
totally.
Well, you're interacting, and you know what I mean. You're developing rapport with all kinds of people, which is critical to what we do.
I think totally, and I think credit goes out to guys like Brian Brider who are teaching improv and theater to lawyers. I mean, look, if you want to be a trial lawyer, you have to have some element of hospitality and showmanship and theatrics as part of your repertoire, as part of your briefcase of tools to use in court. And I just feel like there are some lawyers who become trial lawyers like us, and they don't possess those skills. And it's interesting. I've thought about it for a while. I don't know if those are skills that you can be taught or if they're innate. I think there's a certain degree of just innateness, like you either have it or you don't. But I think you can acquire some of it. But if you're just not a good public speaker, what are your thoughts on this? If you're just not a good public
I
speaker,
I could not
can you learn it or not?
I could not disagree with you
Yeah.
more.
Okay.
Like when I started practicing law, it took me more than 6 months to stop stuttering
Okay.
in the courtroom. I was that nervous. I was that insecure. And being a persuasive trial lawyer is a skill. It is not a talent. It's a skill to be developed. That if you put the work in, this is why this is the golden age of being a trial lawyer. Because anybody that just got out of law school, my nephew just passed the bar 6 months ago. There's nothing stopping him from being a 7-figure trial lawyer within 3 years and an 8-figure within 5. Nothing except his discipline, his desire to. Because if you look at, just take one resource like TLU On Demand, there are literally over 20, I think probably over 2,200 hours of content between 380 webinars and 7 live conferences that are multi-track. And the content, I mean, think about like even the event that's coming up, there's 9 lecture tracks. Your firm has one of them. Claggett's firm is doing one of the tracks. Nick Rowley's operation is doing one of the tracks. So Panish, Rowley, and Claggett are 3 of the top lawyers. Joe Freed and Satch Oliver are teaching for 3 days. Those are some top trial lawyers in the country, and it's not like they're teaching for an hour like they do at most conferences. They're teaching for 6 hours, 12 hours. They're given content. And so that's so critical, that because this thing called trial strategy, how you guys build your cases. It's a courtroom is where it's finished off. Where in the office, before the case is filed, is where it's being built. The medical management, all the things that need to be done to bring these verdicts that you get consistently, that, this whole group gets consistently, to keep bringing them home time after time. That's just one aspect of it, though. The other aspect
No, go ahead.
is the performance aspect. Trial is a performance. And you have to get that it's the thing, the biggest thing in trial, as we all know, once you walk past that threshold of that, into the box or into the jury, is your connection with that jury, whether they feel like you are one, whether they like you. And connection's a skill between, and it's a combination of appropriate eye contact. Like, how do you make appropriate eye contact with 14 people at the same time when you stand up there, and and spread it out amongst them all, so they all start to feel important. Controlling your emotional state of your facial expression. Like, you stand up saying good morning to everybody, say good morning everybody, because you're nervous, and so you allow that nervousness to reflect. Like using your hands appropriately to connect with the jury, like training ourselves to just use one hand, keep the one hand between ourselves and the person we're talking and connecting with. Because when we have 2, it pulls the people's eyes away from our face. But 1, a few inches below our chin, keeps that connection with that person, but all the people around. Modifying, training ourselves to slow down when we speak, because everybody without training will speed up in the courtroom, because it's human nature to become nervous in front of others. This is part of our DNA, and it takes training to get past that. It takes reps, but doing the right reps, not just doing reps. People say, "Oh, you just got to try more cases." I disagree, because they're going to keep trying that same case over and over and over and over,
Right.
without intervention and coaching.
And using these dramatic, sometimes not dramatic, but pauses, like you said, modulate the speed in which you talk, change the inflection of your voice. I mean, you're right, Dan, that like all these things can be acquired. These skills can be acquired. I was simply saying that some people just have a basic innateness of being a good orator, being a good communicator.
What they have, Glassman, is a big head start, okay? You started in grade school, high school, government, public, the student body thing,
That could be true.
debate.
It's a head.
You love talking in front of people because you feel connected to them. You don't feel like you're like a show monkey up there just dancing around and people are looking at you going, what the fuck is this guy doing? You feel like they're listening to you, you're leading them. That's the difference,
That's
is
right.
that you're trained.
That's right. And so doing enough. I mean, I haven't done as many trials as some of the folks you just talked about, but I've done enough. I'm in a BOTA, and I've done enough to know. I've done enough to know this for sure. that there is such a difference between a plaintiff's lawyer who goes through programs like TLU and has been practicing his or her trade and craft and skill than than a defense lawyer who doesn't have that training, that education that's focused on turning them into a better orator, better communicator, better trial lawyer. I mean, like when I get up and do voir dire, there is such a difference between what I do and what the next person does who comes up on behalf of the defendant. It's like night and day. And in my last trial, the defense lawyer was a very experienced guy, probably 20 years older than me, a Boda guy, nice guy, good looking guy, stands up, all of that. But like, there is no connection between him and the jury because he stood behind a podium. He looked down at his notes most of the time. He wasn't listening to what they say. One of the things that I talk about in my jury selection class at Southwestern, which I know we're going to talk about a little bit.
I couldn't wait to talk about
But
it.
one of the things that we talk about is, and I do this over and over and over again. It's like if you're talking to a jury, you pick out Mr. Jones in the first row, and you ask him how he's doing. Thanks for being here. All of that stuff, and Mr. Jones, tell us a little bit about your experience with motorcycles. Have you or anyone close to you ever been involved in a motorcycle accident? And he says, for example, yeah, my best friend died in a motorcycle accident a few years ago. You know what? So many young lawyers and lawyers who don't know shit about how to pick a jury, what they do after they get that.
Run.
No. Whether they say they go, oh, okay. So let me ask you, think you could be fair and impartial in this? Whoa. Slow your roll. This guy just told you his best friend died in a motorcycle accident. Be a human being. You know what you should say after you hear that? I'm so sorry to hear that. I'm very, very sorry, Mr. Jones, to hear that. I'm very sorry. And I'm sure this is very tough then to talk about this type of thing. But just listen to what they say and acknowledge it. Or like it could be the polar opposite of that. How are you doing today? Actually, it's good. It's my 10-year anniversary with my husband. Oh, great. Happy anniversary. Sorry you have to be here on such an important, great day. Sorry. But like just listen to what they say and add, a little commentary about what they say. That helps you form a connection with them. And they then know that you're listening to what they say, and it's not just about a script. You're like, oh, your dog died? Okay. What do you think? You think it'd be fair? I mean, acknowledge what they say. Listen to them. And I'm telling you, when you like judge students and other, younger, newer lawyers and voir dire, you're watching them practice in front of you. So many times they'll just gloss over little details like that the jury tells them, like, oh, my dog died, or oh yeah, my best friend died in this accident, or yeah, like my mom got sued and it ruined her life. Like just respond to that before moving on to your agenda. If your mom got sued and it ruined her life, say, I'm really sorry to hear that. That sounds really rough. Sorry. Just say that. Say you're sorry. I mean, act like you're outside of a courtroom. If someone were to tell you that at a restaurant or at a bar or anywhere, I mean, it's basic human nature to just respond to what they say accordingly. And so many people make the mistake because they're nervous, or they have this script and all they're trying to do is get people for cause and expose biases. But just remember that it is a conversation. And the only way you're going to be able to converse with someone is if you listen to what they say.
Great point. So you've decided that somehow you are adept enough at voir dire that you are going to try to pass on what you've learned to the next generation of trial lawyers at Southwestern. And so tell us about this, this class and why did I mean, I know Rahul teaches over at
Well,
Loyola. He's been teaching there for years, and so what motivated you to start this class, and what do you want people to get from why? What's the why, Glassman?
I'll start with the why. The why is that I was very involved in trial advocacy in law school, and I know that every law school has a trial ad program. Some programs are better than others, but one thing that all the trial ad programs all over the country lack, what they don't teach, a big omission, is voir dire. They just, they talk a little bit about motions in limine, and they jump right into opening statement. And really, when you do a trial ad competition, you're doing, at least at Southwestern, you're doing some housekeeping matters. You practice arguing some mills, then you go into opening statement. Then you put on a couple witnesses on your case, then cross-examine a couple in the other case, and then you close. That's it. That's what trial ad is. They don't teach you jury selection or voir dire. And that, as we all know, is such a critical component to the trial. Some argue it's the most important part of the trial. It is when you get up and talk for the very first time to the jury. And a lot of people think it can break or make your case. So really, the genesis behind it, the origin behind it, was that there is this void in traditional trial ad programs in law schools where they don't teach voir dire. So we wanted to create this class to supplement the traditional trial ad programs and give them, practice and experience of just getting up, asking questions to strangers in the pursuit of getting cause challenges. That's the basic goal of the class. And so the way the class is structured is, first of all, it's only a 1-week course, and it's taught in January of each year, and it's Monday through Friday, 4 hours a day. So it's like a 1-week extensive boot camp type of course, and all we're doing.
It's like a 20-hour class.
Yes, right. It's one credit. It's a 1-credit class.
So what if I hear you correctly? So once you can't see this, but this is the dojo, and in about 2 months, the other half of the dojo will be done. So it'd be amazing, Glassman, if we put together the Robert Glassman voir dire program, but not for law students, because there are some lawyers that need a little help in voir dire.
I think that would be awesome.
And I think the training for voir dire is non-existent because you have to physically get up and practice.
Right.
And everybody just wants to give the words, but not the delivery, not the follow-up, not the conversation.
You can't teach voir dire in a lecture format. It just ain't going to work. You can't sit in an audience and listen to someone else talk about it. You just can't. You have to get up on your feet and do it yourself. So you take a fact pattern, and we'll take a real case that we've done, and we'll introduce the fact pattern to the students in class 1.
I think we should use that motorcycle case that you just did, because there's so much bias involved in it that it's like you have a lot to work with.
So Dave Rudorf for my firm tried a case in front of the same judge in Van Nuys shortly before I did. And what he told me and what other people told me is that she's really tough on cause challenges. She does not grant a lot of cause challenges. So I was going in thinking, shit, I've got a motorcycle speeding in Van Nuys. There's gonna be a lot of bias, and I've only got 6 preemptories. So I hope that what I've been hearing is not true, because I hope I'm gonna have to get a lot of cause challenges. But everyone said she doesn't grant a lot of cause challenges. We picked a jury for a little over 3 days, I think. In this case, 26 cause challenges were granted. 26 were granted. And look, I don't know if it's because she came around and thinks that it's important to grant cause challenges when people are really biased now, or if the bias was just so out of control, rampant in this case. But either way, there was so much prejudice and so much bias against my guy.
Wait, aren't you teaching a workshop on voir dire at TLU Vegas?
I am. Yeah.
This is too exciting.
Yeah.
This is perfect timing.
It will be fun. It will be really fun. And we'll do it on this case. And, there's lots of things to talk about, because you have a governmental entity, you've got a speeding motorcyclist, you've got a lot of stuff.
You got a motorcycle, you got speeding, you got the government entity. So we're taking it out of our own pockets. So that is just those issues right there. Now let's put no helmet on the guy. Let's make him an immigrant that's not documented and Hispanic and can't speak English. Let's really load up the bias
We'll
here.
tweak the facts a little bit.
We'll tweak the
Reel
facts
back.
for but actually, like this is no joking around though. But we should schedule a 3-day, because that gives you enough time. 3-day boot camp workshop, just training voir dire, like in maybe January, February.
January is when we teach the class, but February.
Well, maybe February.
Yeah.
Because then we'll put it together and have some Zoom meetups for people to get to preloaded with what they need to learn, so they get here and they show up and they're ready to go. Glassman, this is great. The birthing of the Robert Glassman voir dire.
I'm ready to do it, Dan. It would be fun.
No, I know you are, buddy. I know I don't have to talk you into this. You're like, you had me at hello.
Yeah.
So we're gonna put this out there. We'll get it put together before Vegas, so that way people that are there that meet you, they could be like, I need to be personally coached by Mr. Glassman.
Well, look,
he's such a prodigy.
Well, here's the thing. There's obviously so many good trial lawyers, and I often think like, who am I? What am I going to impart on people that some of these legends can't themselves? The answer is probably nothing. But what's important?
No, that's not true, because it takes a lot of focus and discipline, energy to impart a skill. It's easy to impart a theory. You could just speak it or write it. If they get the theory, they get it. But when you're trying to impart a skill, you have to be deeply involved and give feedback and coaching, because that's what people need. Is they need a coach.
Yeah, that's true. And again, as we've been talking about, the only way they're really going to get it is by getting up on their feet and trying it, because you don't know your voir dire voice until you practice voir dire. You could my voir dire voice, who I am during jury selection, a big part of it is being genuine. If you're not genuine, they're going to read through it. Jurors are smart. You can't.
Obvious.
I'm not going to get up and be like Brian. I'm not going to do that. And I think a lot of people fall into that trap, but I don't do that. I get up and I try to be as real and as genuine as humanly possible. But still, you don't know what you're going to look like, what you're going to sound like picking a jury in front of a mirror. You have to practice it in front of 12 or 18 live bodies, where you're going to get different responses. And like we talked about earlier, you can't just stare to the left side of the box the whole time, or you can't just look at the center of the box or the right side of the box. You have to be constantly roving and engaging all 18 people in that box, and sometimes more than 18. You got to be engaging them at this, simultaneously. You can't exclude like the guy in the back row on the right. You just can't do it. So until you practice making eye contact with 18 people at the same time, you're not going to be well equipped to do it for the first time in real life. And unfortunately, I had to learn the hard way, because I didn't get to practice voir dire before I did it for real by myself when I did my first chair trial down in Vista as a young lawyer. It was scary as shit. I didn't have a paralegal, a law clerk. No one was taking notes from me. I didn't have anyone to consult with about who I should, try to strike, or, what exactly that person said, so that when I go in chambers and try to exercise some cause challenges, I didn't have a note taker, nothing. And look, it was good that I was thrown into the fire like that and had to do it all myself. But now, at least you'll have some reps in or some practice if you go to, classes like TLU, or you take the Southwestern class if you're in law school. But what we've tried to do,
or come to the Robert Glassman voir dire masterclass,
or do that. But what we're trying to do is just encourage others to do it too. Rahul.
Hold on, before we go any further, what was the verdict?
It was 11 million 40.
No, your first trial.
The
one you were just talking about.
Okay, so that first trial was down in Vista, again, a few years out from law school. It was 1.55 million. But let me tell you about it. It was disputed liability. I represented like a 25-year-old guy who had 3 epidurals. And that was it.
First of all, you started off with a 7-figure verdict. Sadly, it took you about, what, 13 years to get to 8. We're not going to talk about it, though. I'm sure there's been enough at that firm of yours. I know enough people there between, especially Panish, Shea, Ravapudi. I mean, all the, Lucas, especially those. I can imagine it's like a locker room over there. The harassment you must have suffered for not being able to properly
Well,
contribute.
I think we talked.
They made you a partner without any. They must really like you over there because with your limited credentials.
Well, I was trying to bring in a good amount of cases. I've been fortunate that I've been able to do that, and I've gotten good results. But what
You're like, I was better bringing them in than I was bringing them home. Okay, I brought them in teed up, Panish
totally,
and Rob Booty.
yeah, just give, and then I pass them off to Tom Schultz to knock him out.
There we go.
But what I had to my, what I could use back then was like, I'm not even 40 years old yet. I'm not even 40. Give me a break, And and I think we talked about it. It was a goal of mine to get my first 8-figure verdict before I turned 40, and I got it on the day that I turned 40.
Well, you gave your closing on your 40th birthday. Did they give you the verdict that same day?
No, next day.
Oh,
Yeah.
I think you're kind of like
I missed it by
you're kind of
24 hours.
yeah.
But that,
It's a little bit of an exaggeration.
I'll never forget March 20th, 2024. And really March 21st, 2024. That's March 20th is my birthday. I turned 40. I gave like a 4-hour closing argument. It was crazy. She just let me go. But it was disputed everything. And
That's
it was
awesome.
tough. There's major impeachment issues that I had to address and talk to them about. And it was just so cool for so many reasons. We haven't talked about this, but we'll talk about it in Vegas. There were major impeachment issues. My guy wasn't
Okay, hold on a second. So let's,
okay.
for purposes of conciseness.
Yeah.
So Vegas, October 16th through 19th, 2024, Caesar's Palace. One of the tracks we got is the Panish, Shea, Ravapudi, and Glassman track. So I first want to say I'm stoked as hell about this because from the time I met, Brian and got to know people at your firm over the course of the pandemic back in 2021, I'm like, Panish, you need to have your own trial program. You've coached all these great lawyers. I mean, nobody's got more 8-figure lawyers as part of their firm and kept the team together, which is, I'm just, most impressed with that because, some trial lawyers, especially when they start hitting 8-figure verdicts, they got these things called massive egos, which are hard to contain. Thank God all the people I deal with are not egomaniacs, all super humble, great people, but there are some egomaniacs out there and they're kind of hard to deal with. That was all sarcasm, by the way. I thought you'd start cracking up there because but so finally in 2022, we did the first PSR trial college at Marina Del Rey. That was great, but I just think it's so much better. It's like having a small local college, liberal arts college, as opposed to going to like Yale or Stanford or Harvard is what I consider TLU to be for trial lawyers because it's like the best of the best. And most we've heard of, some we haven't. But even if you haven't heard of these people, it doesn't mean they're not ripping, consistent 7-figure, 8-figure verdicts like my buddy Kimball Jones. He's a local lawyer here, Bighorn Law in Las Vegas. 3 trials in the last 30 days, 7 million, 13 million. The 13 million one, 2 of his young associates tried it and he was in the court, but he let them do the voir dire, the opening, the closing, the rebuttal, the majority of the witness, and he just coached these young. Can you imagine how inspiring that'd be? And $103 million verdict, all within 90 days. That's an insane. But like to have the processes in place to do such a thing. But nobody's ever heard of the guy because, he's just working his ass off trying cases and not, being on Instagram.
Until October 16th, 2024. And after that, though, we will
have heard of him. But I think that's just so amazing. You know what I mean? These people all over the country just doing such great things and coming together and sharing it. This is the 3rd year we've done it here in Vegas.
Here's some real truth. Here's some real candor for you. It is hard work getting ready for these conferences. I've got 80 cases on my list. I've got a trial in October. I'm working on this ridiculous motion for summary judgment right now on a huge case against Target. There's all this shit. I've got 3 kids, a wife, just everything's going on. And then we get a call from like Brian, or Peter, whoever, we're doing TLU in October. Get ready. You got to fucking get your shit together, your CLE stuff, your topics, blah, blah, blah. Like, oh my God, another thing put on our plate. Holy shit. But the truth is that once we're doing it, and then after we do it, we're so glad that we did. It's so fulfilling to go through the process of getting ready for it, and then of doing it, and then sort of like reaping the benefits of it. And what I mean by reaping the benefits of it is just like meeting new people and having just one person come up to you or email you afterwards and say, like that was really helpful. Like if one person can walk away with one skill or one phrase that they're going to try in their next voir dire, or a theme that they're going to try to use in their next opening statement or throughout the presentation of evidence, like that is really fulfilling for us. So I'm just trying to, I don't want to like be too nice to you, but I want to say that it's a pain in the ass to get ready for it. But once we do it, we're so glad that we did. And it really is fulfilling.
And I'm a pain in the ass to do it.
And then, yeah, on top of like,
I'm on top of it. People aren't doing what they're supposed to be doing. I'm ratting you out to Polos and Panish, being, what the hell are these people doing, Panish? We're on them, man, bros. Good. Come on, coach. Let's get this team in order.
Like, I'm here. So I'm here right now.
No, I know. No, it's been.
I'm here doing this.
No,
it's great.
Yeah, it's been so great, and like I was so blessed during the pandemic because I, really out of all the, like I met more people from your firm and did more webinars, I think, with your firm than any other firm. I mean, obviously Claggett did more programs. He probably did 40 or 50 programs, but you guys did that many, probably maybe amongst your whole firm. So I got to know you, Rudorfer, Ravapudi, Shea, Lucas. I mean, and then some of the guys that, are no longer with you that were, really great young lawyers to, work with. And, like, it was so great, like Stump,
Right.
I mean, because like, I know like him and Boyle started their own thing, went their own little boutique thing, but still it's just like great people.
Totally.
And I was so like, and to become friends with all these people and get to know them and get to learn from them because, Panish, helped you guys, and, Bravo Pudi helped everybody, work together to become who you are. And, it was, for me, it was like the pandemic was the, obviously the greatest thing that ever happened. It wasn't like, boy, I wish the pandemic didn't happen. It's like, I'm waiting for the next one. I don't know what kind of virus is going to contaminate the world, but shit, that's nature.
Right.
Shit happens. I'll be ready.
It's so funny when you meet people out in public and, they say something like that because you're not really allowed to say it out loud. Like, oh yeah, you kind of have to say like the pandemic was like awful. It was terrible. But there's so many people who are like, I actually kind of liked it for whatever reason.
It was awesome.
I met a lot of people, or I got to spend time with my family. It's like one of those little, secrets that you tell people in the corner of the room. Like, I actually kind of liked the pandemic. I got to spend more time with my kids or my family, or I met all these people, or I became a better trial lawyer.
Yeah, or I got to meet all the best trial lawyers in the country.
Right.
That was my thing.
Yeah, it's true.
Build a platform.
It's true.
You know what I mean? Because like I had no idea that anything I was doing would ever become anything. I just didn't have anything else to do. I was all by myself. I just needed companionship, somebody to talk to.
Right. And now,
little did I know it was gonna be Keith Mitnick, Brian Panish, Sean Claggett, Nick Rowley, Randy McGinn, and on and on. Little did I know that, these would be my Zoom friends.
Right.
So in Vegas, besides this voir dire workshop that you're gonna be teaching, you're also gonna be teaching something on what?
Well, so we're gonna break down, do a case analysis of our verdict this year, our motorcycle verdict that we got 11 million on. Like I said, disputed everything. We're going to talk about the voir dire in that case. We're going to talk about the presentation of evidence and how we prepared our witnesses, how we prepared for cross-examination of the defense experts, and then how we tied it all together in closing argument. And one of the things that I'm most proud about, honestly, that verdict, it's not so much the number. I mean, the number was great, 11 million in Van Nuys and the speeding motorcycle case is great. And they didn't offer any money before. The the highest offer they had made at any point. They didn't make any offers beyond this at trial or anything, but the highest offer they ever made was $750,000. Never went up, nothing. Um, but the thing that I'm most proud about the verdict is, you know, again, it was undisputed our guy was going 16 to 35. So I didn't want to lose credibility with the jury. That's fast. That's fast. Our guy was speeding. So in closing argument, I got up and I said that I'm not going to stand here and say that what he did was okay or safe. Uh, he shouldn't have been speeding. He should not have been speeding. Okay, and so if you think that that wasn't the right thing to do, or if that was negligent of him, I can't really disagree with you. But what we've seen for the last several weeks is that his speed was not the cause of this accident. And I was able to show that had he been going slower, the accident would have still happened. And I was able to use my recon and my biomech to say that even if he had been going at a slower speed, he would have suffered the same injuries, all that kind of stuff. So I really focused on the causation prong of that analysis, that, it's a two-step analysis to find comparative fault. You got to say that the guy's negligent and that his negligence was a substantial factor. So I focused a lot of time on him not being a substantial factor, right? So you know what the jury did? They came back, they found our guy was negligent, but they put 0% of fault on him, zero comparative. So that 11 million plus verdict, it was all attributable to the DWP. And I learned a lot from that. I learned that it's okay to concede that your guy may have been negligent, but that is why the law separates negligence and substantial factor. And this jury, they were conservative. They were probably Trumpers, but you know what? But they followed the rules. And afterwards, when we talked to them, they said, like, yeah, your guy was speeding, wasn't probably the safest thing, but like it was clear that that wasn't the cause of the accident. They did their job and they did the right thing. And so I learned a lot from that. And, I'm going to certainly make concessions like that in the future if I believe, after digesting all the evidence, that my guy's negligent. I'm going to say he is. But if his negligence wasn't the cause, then it's not the cause. Because look, we all speed, Dan. I mean, we speed all the time, right? Their expert said, look, we all speed. It's just what we do. It's human nature, right? And so I use that trial testimony in support of this argument of kind of separating negligence and substantial factor. And the jury instruction on speed also talks about that you can be speeding but not be a cause of the accident. Conversely, you could be going under the speed limit and you could be negligent. So the speed is it's situational. If you're speeding on an empty road with no one around, is it negligence? Maybe not. If no one's around and you're not going to pose a threat to anyone. So you got to look at the context. And here in this case, we looked at the context. The jury looked at the context and they said, yeah, he was negligent, but he was not a cause, not even 1% a cause of this accident. So I was most proud about that.
Great. So let me ask you, Mr. Glassman, speaking of voir dire, how did you approach the voir dire in this trial?
Well, a lot of it was set up through my mini opening statement. In my mini.
You know what? I think to put the voir dire in context, give us your philosophy on the mini opening and kind of how you delivered it, and then give us some context on the voir dire, because this whole trial is the voir dire.
Yeah, well, I think it's my philosophy is in alignment with a lot of other people's. You got to get your bad facts out. You got to get your bad facts out during your mini opening. You don't want to sell your case in mini opening. You're trying to highlight the bad pieces of evidence so that the jurors who are going to rule against you already are going to be even more motivated to rule against you once they hear those bad facts. And they're just being honest. They're just being honest with their feelings. If they hear that there's a guy speeding his ass off on a motorcycle, it's not going to be agreeable to them. They are not going to like that, and they're not going to be fair. And that's fine. That's exactly what we want, right? We want that brutal honesty during voir dire. We want people to be honest. And so a big part of my mini opening, and it's like 3 minutes long, was talking about how, look, you're going to see a video of this accident. You're going to hear that the plaintiff was going about 25 miles over the speed limit. And you're going to watch the video, and we're going to play it for you a bunch of times. Both sides have agreed to play it. And that's what you're going to hear. So, the purpose of the next several hours or days is to find out how you feel about all this kind of stuff. That was essentially my mini opening. And I mean, that tainted, that shifted the mood in the room tremendously. I mean, you know, again, 26 cause challenges is what we got. So, I mean, most people said, look, I don't like personal injury cases to begin with, but now that I know that this personal injury case is about a motorcyclist who is going like 60 or 25 miles per hour over the posted speed limit, I'm sorry, Mr. Glassman, but I don't care what other evidence we're going to see. I've already made up my mind. I think this guy's at fault, at least to some degree. Maybe if there's evidence that the van driver was drunk or on drugs, I'll change my mind maybe a little bit. But no matter what, if he's going 25 over the posted speed limit, I've already determined that he's at least some degree at fault. And most people said that. Every single one of those people were struck for cause, because you can't make up your mind about who's at fault and who's not at fault during jury selection. So a lot of
Do you have a transcript of this jury selection?
I do.
Great. Why don't you should send it. Well, we're doing a case analysis on this September 6th.
Yeah.
So make sure you get all the pleadings, transcripts, and PowerPoints to Rose for the file cloud library, because I think it's just really instrumental for people just to read the transcript. I mean, it's one thing to talk about voir dire, it's another thing to read it and see how you sequence the questions, how you set up the 4 cause challenges, how you spread the venom, how you dealt with these. Because you could talk about it, but it's nothing like reading the transcript.
That's right. And I think something that people need to understand too, who have never done it before, is voir dire is very freeing. It's very liberating, because you're so scared about your bad facts. Like, I was terrified of the speed, right?
You should have been.
But during voir dire, it's okay. Embrace it. That's very liberating, right? Because you talk about how bad it is, and everyone else is agreeing with you, and you're getting all them for cause. Dun, 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 done. And then when you whittle it all down, in our case, we were fortunate that we had 12 people who were like, look, we hear the speed. We got to wait. We're going to wait to hear everything. And those are the people that got into the box. And they are the ones that ultimately were super, by the book, fair, listened to the evidence, weren't swayed by sympathy or bias or prejudice, and did the right thing. But I think, people need to be reminded that in voir dire, it's actually very liberating and free, because you can let your guard down and talk about your vulnerabilities and all your bad facts. That's the only time in the trial, really, where you want to embrace it. All the other time, you're trying to minimize it. The speed didn't mean shit. The speed wasn't shit. But during voir dire, it's like,
okay, so let's get some specifics. How did you voir dire on the speed? This is going to be trial tips on voir dire from Robert Glassman, because that's I want to know how you voir dired on the speed, and then on the government entity. Those two right there. Let's start there.
So again, it all starts in mini opening. So they already know that the guy is going 25 miles over the posted speed limit. So they already hear that. So then I start with voir dire, and after some preliminary introductions and greetings, welcoming everybody, I started with my first bias point. My first topic was the speed. I said, look, you heard just a few moments ago that there's going to be some evidence in this case of the plaintiff traveling at close to 25 miles per hour over the posted speed limit. if that's the evidence in this case, and you're going to hear that, Miss Jones, let's start with you. Do you have any feelings about that? I mean, do you have any strong uh, feelings or otherwise about it? And she'll start saying, yeah, I think it's terrible, and I can't believe it, and I don't even understand why we're here, or he's clearly at fault. I mean, that's so reckless, that's so dangerous. And then what you do is you thank her for being honest, appreciate your honesty. That's what we're looking for. And so based on those kind of strong feelings that I think I'm hearing from you, do you think it would be difficult for you to kind of treat my side similarly with the defense side? Do you think you'd put us kind of both at the same starting point in this case, or am I starting behind the defense here? Well, I think you're starting behind the defense. And do you think it would be difficult for you to treat both sides uh, fairly in light of that evidence? Yes, I do. And based on your personal feelings, and based on those strong feelings, do you think it would just be too hard for you to be entirely impartial in this case? Yes, I do. Thank you very much, Miss Jones. I appreciate your honesty. I appreciate you being here. Does anyone else feel like Miss Jones feels? Yeah. Juror number 7, Mr. Smith. Tell us about that. I agree 100% with her. Do you think that it would be just too hard for you to be entirely impartial in this case? Yes, I do. Thank you, sir. You got to know the buzzwords that are in the statute that constitute bias for cause. Actual and implied bias for cause. And in California, the key words are entire impartiality or entirely impartial. So if you can get the jurors to say that they can't be entirely impartial in this case, they have to be struck by cause. That's the language in the statute. But Dan, you can't just go straight into that question. It's almost like you're leading the witness. You're leading them to that conclusion of they can't be entirely impartial. So you start off with I have like a formula. You start off with just some, really open-ended questions. Tell us how you feel about some of these issues that we've talked about. And then just let them pick, player's choice. They go, well, I don't believe in suing the government. I think that's bullshit. Okay. And then follow up. Thank you. First of all, thank them for everything. If you become combative with a juror, you're done. You lost. You lost the case. So you never become combative with the juror. You thank them profusely for everything.
Even if they're wrong?
Even if they're wrong.
Glassman's a joke.
So much. Thank you. Yes. Bring more of that wrongness. How long have you felt that way for? My entire life. Wow. Okay. So it sounds like it's a pretty, you felt like this for a long time. Yeah. And
deeply held belief.
But that sounds.
I can't talk you out of it.
That sounds like a little lawyery. But is there anything that I'm gonna say, or Mr. Jones, the defense lawyer over there, is gonna say, or the judge? Is there anything the judge is gonna say to make you change your mind about that? No. And do you think it'd just be a little difficult for you to kind of treat us kind of the same in this case? Yes. And based on everything you've said, do you think it would just be a little, just too difficult for you to be entirely impartial in this case? Yes. Thank you. I appreciate it. And does anyone else feel like that? And then you get all these hands, right?
Who else feels even a little bit like Mr. Jones?
Right.
Gotta lower the barrier. That's okay. Don't you? I'll coach you too. I know you're the coach, but
yeah,
give me some feedback because you got this 8-figure verdict now, so the ego's riding high.
Yeah.
I get
it's
it.
a long time ago. The ego's already gone. I'm done.
So Robert, how do you talk about the government entity part? Because that's always a factor, especially like in California where they're, people sue the government. Places like Florida, you can't sue the government for more than $200,000. So not really relevant. But how did you talk about it in this case?
The big bias topic in voir dire, in any case involving a public entity. But you can start off the conversation by saying some people think. Now, I want to talk to you about something else now, and something that I've got concerns about. But some people think that it's wrong to sue the government because it will raise taxes for the rest of us, or that it's going to bankrupt the cities or bankrupt municipalities. It's going to be bad. It's just going to be bad to do that. So um, so so does anyone here feel like that? Does anyone here feel like it's a bad thing to do? That we shouldn't do it? That there should be some kind of immunity, or you just shouldn't do it? Does anyone have thoughts like that? And then from that discussion, it's typically a good transition to talk about caps on damages. So I usually, from talking about the governmental entities bias, you can transition nicely into caps and whether or not people think that there should be any type of cap on cases involving the DWP or any other type of department in the government. Has anyone thought about that before? Does anyone think that there should be, by a raise of hands? So I think that's typically how I talk about it if there's a case involving a public entity.
Sounds good. So we're gonna do this case analysis on September 6th. My buddy Shemek Lubecki, I told him about that. He said I get to host Robert Glassman. Actually, he paid me to host you, so it's another side business I got, hosting the
Do
superstars.
I get a cut of
Getting
that?
him,
Do I
what?
get a
Of
cut of that?
course,
Okay, good.
of course, dude. Of course, we realize that PSR folks don't perform for free.
Hey,
Come
my
on,
case is
buddy.
up on appeal. I haven't seen anything from that.
I know. I don't know how you're paying the rent. But anyways, Mr. Glassman, I know you're deeply involved with the students and the future of the trial bar. And I too am very focused on that too. And so my goal is to get 100 law students to Vegas this year. And we're going to give them scholarships. So, and because this way it's the future. Imagine if we got to go to a program like TLU in law school. Could you imagine what that could do for the future, especially all these people that are now interested in being plaintiffs lawyers? So if anybody is a law student, would like to come to TLU, you can send me an email, Dan@Trial Lawyers University, and tell me A, why you want to be a plaintiff's lawyer, and B, why you want to come to TLU. And it's a strong likelihood it will happen for you. So I'm looking forward to that, because nothing more exciting than a law student, right? All that joy and ambition and good warm art, going to be great.
It's a great perk that you're providing them, and so we're gonna hit Southwestern, Loyola.
Yeah, hard,
all
Panish,
the LA
because we got 3 famous graduates: Panish, Glassman, and Shields. That's my nephew
Right.
Harrison. He just graduated 3 months ago. He's going to be famous one day.
Is he coming?
Not well known now, but one day.
He will be. He will be. No, that's great.
One
Man,
day.
we didn't have stuff like that when I was in law school. So
Oh,
we'll get people there, and it will be a great learning experience for them for sure.
I'm stoked. So, Robert, how do people get a hold of you?
So I'm at Panishe Ravaputi. My email is rglassman at panish.law. My number is 310-477-1700. Shoot me an email. Call me for anything at any time. My wife knows I am 24/7. I am working under the covers. I am working on vacation. I am working all the time. So again, one of the great perks of this is just meeting other people who are participating in the
The best.
university as well.
I mean, that's the perk, the community, all the great people get to know.
I'm also on
and
Instagram,
become friends with.
Bobby GESQ. You can follow me on Instagram as well.
All right.
Not quite
You and Alder and Brighter, all Mr. Instagrams.
I like Instagram. It's good.
All right. And if anybody else needs, everybody's got my email, and my cell is 248-808-3130. If there's anything I can do for you, anything I can help you with, any documents. Sometimes people shoot me emails, want my cross-examination of the defense medical expert, which I'm very proud of. But anyways, anybody ever needs anything, you got us. Thanks for joining us, Robert.
Thank you.
Take care.
Look forward to seeing you in Vegas.
You got it.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.